We're going to give a little bit of a general introduction about the court system so you understand where landlord-tenant disputes fit in. And I'm also going to do a plug. 2023 is a judicial election year. It's really important that you get out to vote. We at PMC do hold an appellate court candidate forum. It will be on October 24th on Zoom. You can find out more and register on our website at www.pmconline.org. But you need to learn who's running for the positions, what the positions entail, and I can't urge you enough to get out and vote. I want to thank Judge Petite for joining us first. He is one of our favorite presenters here. He's actually been presenting for PMC with PMC longer than I've been the CEO of PMC. So I truly appreciate it. You've shown me the way. And this is just a little bit at first about our judicial system. Next slide. So, where do landlord-tenant disputes fit in, right? Judge Petite, tell us where they fit in.
Well, when you look at the entire court system, you see the Supreme Court at the top. Can they see that slide there?
Yes, they should. Sarah, can they see it? Okay.
If you can't see it, what sits at the top of the Pennsylvania Unified Judicial System is the Pennsylvania Supreme Court, and they're the highest court in the land. Then you have your intermediate level appellate courts, which are your Commonwealth courts and your superior courts. They hear appeals from the Court of Common Pleas, which is our trial court. But at the bottom down there, you see Pittsburgh, you see the municipal courts. There's a Philadelphia Municipal Courts, the Pittsburgh Municipal Court, and the magisterial district judges are at the bottom to the right. And but we are a part of Pennsylvania's unified judicial system. And Title 42, Section 1515 gives us jurisdiction over these type of disputes. And landlord and tenant cases fit right into that jurisdiction. Our jurisdiction is up to $12,000 now. It's probably one of the highest in the country. If you watch a lot of court TV, Judge Judy only goes up to $5,000. Well, we go up to $12,000, but Judge Judy made $40 million last year. So, in any event, that's kind of where the magisterial district courts fit in.
And a lot of I'll say a lot of the litigants in magisterial district courts are self-represented or pro se litigants. Isn't that true?
Exactly. Most of the cases that come in front of me, particularly with respect to landlord and tenant cases, people are representing themselves.
So it's important. We are not giving you legal advice. The judge is not giving you legal advice. I am a lawyer. I'm not giving legal advice. But we're trying to give you information so that you can help represent yourself. If you have a question when you're in the courthouse, sometimes the clerk's office or assistants can direct you to resources, but they too can't give you legal advice. So you know that. And then, depending on where, and we'll discuss this, where you file, like there are bar associations, there are legal aid organizations that can help you with your filing. So it's important for you just to know your resources, know where to go, and how to start representing yourself or protecting yourself, I'll say. So we had the triangle, and I say that the entry level courts are the magisterial district courts or the municipal courts. And when we're gonna just do this briefly, but if you get through the magisterial district court, there is an opinion and result, and you are not happy with it, there is always an opportunity to appeal, and that would be to the Court of Common Pleas. Court of Common Pleas is also an entry-level court for matters over $12,000. So it serves a dual purpose, I'll say. When you appeal to the Court of Common Pleas or you start a matter in the Court of Common Pleas, it starts all over. In other words, like the appeal starts the case anew. What happened before is not looked at as an abuse of discretion, which is a standard which sometimes appellate courts look at for lower court decisions, but it's reviewed de novo. The Court of Common Pleas is a broad-based court, handles many different kinds of matters in Allegheny County. Aleo, can you turn the next slide? The president judge of the Court of Common Pleas in Allegheny County is Judge Kim Berkeley Clark, and Allegheny County is divided into 4 different divisions. There's a civil division, a criminal division, a family division, and orphans court division. Some counties in Pennsylvania do not have, I'll say, enough population, enough activity for the court to be divided into civil, criminal, family, and orphans. And so a judge is, I'd like to say, a general practitioner who handles, civil and criminal and family and orphans sometimes. So, maybe they handle them on different days, but it really does depend on the size of the county as to how the court is set up. Here go back one slide. Here in Allegheny County, any kind of appeals of landlord tenant matters or original jurisdictional landlord tenant matters would be in the civil division. Orphans court is, I like to point out, a interesting name because it's an old Latin name, but it really deals with wills and estates, guardianship, adoption, and civil commitments. But it's still used in current times. Okay, go ahead, Leah. And so now Judge Petite briefly talked about our appellate courts, and the triangle is such that you had the entry-level courts of the magisterial and municipal court. If it was higher than 12,000 or an appeal, the next level is the Court of Common Pleas. After the Court of Common Pleas renders its decision, typically that too could be appealed. You may not be happy with the decision, so you can appeal it. Usually an appeal of a civil matter goes to Superior Court. That's one of our intermediate appellate courts. The other is our Commonwealth Court. It is a unique court. We'll discuss that in the next slide. So our Commonwealth Court, we have a female president judge. The Commonwealth Court is unique to Pennsylvania. No other state in our country has a Commonwealth Court. It was created actually to help alleviate some of the pressure on our Superior Court because it too is one of the busiest courts in the country. It typically hears brought by the state. It handled, for example, recently, it handed down an exceedingly important decision dealing with the funding of education in Pennsylvania. It was a case that lasted for over 7 years. It was a trial that was in front of a judge, not a jury, that lasted for months, and the judge issued an 800-page opinion that said that the funding of education in Pennsylvania was unconstitutional. And now we leave it to the legislature to try to figure out how to make it constitutional. Next slide. So as I mentioned, our Superior Court is the court where if you had a matter of landlord tenant and it had been in the Court of Common Pleas, you weren't particularly happy with the result, you could appeal it. Our Superior Court, I like to say, doesn't have discretion. So every case that gets appealed to it, they have to issue some kind of decision. They can say they're not ruling on it. They can decide that they're going to rule on the papers. They can decide that they want to hear it, but every case can be appealed to them. And so that's why they're known as one of the busiest courts in the country. And these are some examples of cases that the Superior Court, could handle. A nursing home arbitration agreement, for example. And I want to point out that while we call them our intermediate appellate courts, they have the potential to be the final authority on Pennsylvania law. So when the Commonwealth Court issued the decision about education funding in Pennsylvania, it wasn't appealed to the Supreme Court. So that decision is the final law in Pennsylvania. Similarly, Superior Court decisions aren't always appealed or aren't always taken by this Supreme Court. So their decisions could be the final law in Pennsylvania, final interpretation of the law in Pennsylvania. Next slide. And our highest court in Pennsylvania is our Supreme Court. It is, again, the ultimate authority in matters brought, interpreting Pennsylvania law, but its review is discretionary. So it doesn't have to take every case if it doesn't want to, unless it's a case involving a death penalty. It also has this unique power called King's Bench, where a case could actually get started in the Supreme Court by the filing of a petition asking for the court to interpret a law or a statute or something unique to Pennsylvania. They don't always take it, but lawyers like to try to do that and sort of skirt around the typical route because it's a long route. Okay, next slide. Our Supreme Court has a president judge who is a woman. She was just installed this year. She is the first female president judge of our Supreme Court in over 300 years. We have a vacancy on our court because typically there are 7 justices on our court. And unfortunately, one justice passed away last year. So we have 1 spot that will be filled in the November election. Next slide. Oh, something happened. Next slide. So our court also has duties other than sitting on the bench and hearing cases. It has a judicial conduct board. I say this because our judges have a code of conduct that they have to abide by. We have seen and heard a lot about the Supreme Court of the United States that who don't have a code of conduct, but our judges in Pennsylvania have a code of conduct that they have to abide by. And if there's a complaint, it goes to the Judicial Conduct Board. Our Supreme Court also has various committees that they oversee, rules committees, such as, if they want to change the criminal rules, or they're looking right now into changing the rules for bail. If they want to change rules of evidence, rules of civil procedure, they propose rules, they publish it, and they wait for comment, and then they make decisions as to how the rules should change. They also regulate the practice of law. They, set rules and guidelines for attorney admission and discipline. Next slide. So that was my quick spiel about our court system, so you understand it, because again, I'm going to sound like a broken record. Don't forget to vote in November. Okay, we are now here to talk about landlord and tenant rights and responsibilities. And as you know, renting a house or apartment, even purchasing one really is one of the most important decisions you can make. And I'm going to say throughout this, and I know Judge Petite says this as well, communications is key. You need to make sure that you communicate. If you're a landlord with a tenant, if you're a tenant, communicate with the landlord. That oftentimes cases go to court because there's this breakdown in communications. Next slide. Judge Petite, do you want to discuss this?
Yes. Well, one thing landlords can't do is they can't discriminate against people for reasons of race, color, age, religion, and national origin. Under the federal and Pennsylvania laws that tell us that all individuals have rights against discrimination when they are searching for housing and when they become tenants. Instances of discrimination require the tenant to go to court. Instead, if a tenant feels that they have been discriminated against, they may file a complaint with the Department of Housing, Pennsylvania Human Relations Commission, or your county's Department of Human Rights, and the Pennsylvania Attorney General's office. What's an example of discrimination? Landlord says that the rent is higher than advertised after meeting the potential tenant in person or falsely denying that a unit is available for rent. Landlord does not allow full use of all of the home facilities or requiring you to live in a certain part of the building. An advertisement states that a property is only available to people without children. Refusing to permit a person with disabilities to make reasonable modifications to the unit, or retaliation against you for opposing housing discrimination or for filing a complaint about discrimination. What would be a form of retaliating against you? Let's suppose you're on a month-to-month lease and you file a complaint against the landlord. Well, Next thing you know, you're getting a 30-day notice that they want to evict you, or your rent's $500 a month, but suddenly it goes up to $1,500 a month. That may be considered a form of retaliation. So let's talk about tenants' rights. Implied warranty of habitability. The rental unit must be in fit and habitable condition. So what does that mean? That means that you can't have sewage back up in the basement. All of the electrical outlets should be working. The windows should work properly. You should have adequate heat, adequate electricity, and you should have a good resource for water. All those things should work. There can't be any holes in the ceiling. The rain shouldn't be able to come into your unit. There are so many issues with respect to habitability. There's an implied covenant of quiet enjoyment when you rent a place. In other words, when you rent a place, it's supposed to be habitable. And you also are supposed to have the right to use and enjoy your rental property without reasonable interference by the landlord. Now, when it says implied covenant of quiet enjoyment, it's not talking about noise. Okay, a lot of people get that mixed up. It's talking about the right to live in peace and to be able to live in your unit to the fullest extent that you can live there without violating someone else's rights. You know, landlord can't be calling you every day or every other day or wanting to come by and see how you're keeping the unit up. That is not peaceful and quiet enjoyment. That is interference by the landlord. Or the right to exclusive possession of the residence, expectation of privacy and unlimited access to the property. The landlord can inspect property with notice and can enter property in emergencies.
Next slide.
So landlord has some responsibilities. What about the tenant? Tenant has responsibilities too. A tenant's main responsibility is to pay the rent and to pay it on time. Now, there are two kinds of breaches. A material breach is considered if you don't pay your rent, or if they find drugs in your unit, that may be considered a material breach. But your responsibility is to pay the rent on time. Most leases require that the rent be paid by the 1st of the month. Some leases give you from the 1st to the 5th, and then after the 5th, you have to pay a late fee. You must obey all the terms of the lease. If the landlord states that the tenant must pay utilities, the tenant must get the bills from the landlord. Make sure to get a signed copy of the lease to monitor the rules and terms so you can obey them. The tenant must communicate with the landlord about repair issues as soon as they occur. What's an example of that? Every 10 minutes you hear your toilet running through the walls. And it wasn't doing that when you first move in. And then it just kind of stops. And then at the end of the month, you get a $500 water bill. You're supposed to report that kind of stuff to your landlord so they can come by and look at that situation immediately, particularly if your water bill was, let's say, $80 a month, and now it's $500 because your toilet was running and nobody communicated that to the landlord. It's best to do this in writing and to keep a copy of the notice. The tenant should return the property to the way it was when they moved in, minus reasonable wear and tear, removing all belongings. Now, I've heard a judge say on TV, if you got a toothbrush still left in the unit, you're still there. Now that may be stretching it a little bit, but you have to remove everything from the unit. And when we talk about normal wear and tear, you know, certainly you can't be talking about a carpet that's been there for 20 years. And they spill something on the carpet and you want them to replace the carpet in your entire house. That would not be reasonable. Now, if you paint the walls and they were white when you moved in, you may have to paint them back to white when you move out.
But I always say you need to make sure you have a conversation as a tenant, right? Sometimes people rent apartments without a lease. It's always best in my mind to put it on a piece of paper so that everybody is on the same page and is going into this legally binding agreement with the same understanding. So if you know you want to paint it purple, blue, yellow, you could say something to you being the tenant, you could say something to the landlord. And if the landlord says it's okay, then make sure it's in writing. Next slide.
Absolutely.
All right.
So what are the landlord's rights? A landlord can set rules about how the property and common areas can be used. Landlords are entitled to have keys to the property. If the tenant changes the locks, must give the landlord a copy. I've seen situations where tenants have added deadbolt locks to doors, and the landlord can't even get in case of an emergency. If you do that, first of all, you should get permission to add a deadbolt lock from your landlord. And once you do that, you should provide them with a key. Landlords have the right to evict a tenant using the judicial system. If tenant does not pay rent or does not pay on time consistently, or if the tenant breaks or breaches the agreement in the lease, not all breaches require a landlord to evict the tenant. Some breaches can be correctable. Let's suppose you're playing your music too loud. Well, you can turn it down. Okay, that's something that's correctable. Let's suppose that you haven't paid your rent in a couple of months. That might be correctable, depending on how much time is left on your lease. But the landlord cannot just lock your doors. That's considered self-help, and the landlord could get in trouble for that. He would have a serious, or she would have a serious legal problem. Landlords must pursue evictions through the court system. There's a reason for that. It used to be many years ago that they just lock the door, change the locks, and put your stuff out on the street. Imagine if that happened today. It not only creates a public safety issue of having people on the streets, but also it just doesn't give the tenant any due process rights to be heard in a court. Landlords may require a security deposit, and the security deposit should not be more than what twice the rent is. So, for example, if the rent's $500 a month, they can ask for security deposits of $500, but up to $1,000. Landlords are not responsible for a tenant's personal belongings. Okay. And on that note, I would consult my insurance company to get apartment insurance. Many people don't get apartment insurance, and it's pretty cheap. You know, if you ever priced it out, you can find out that the apartment insurance is pretty cheap. And because if something happens in the unit, there's a fire or there's a flood or something like that, the landlord has insurance on the building, but they don't have insurance on your stuff inside the unit.
Yep. I just had a situation with a friend who had mold in the apartment, and so it ended up on the couches, the cloth on the couches, and the landlord, did repair the mold in the unit, tore the walls down, brought in a mold, but they told the tenant to, they had insurance, to contact their own insurance company in order to deal with the couches and the furniture.
Wow, that's interesting. Now, what are the landlord's responsibilities? Main duty is to maintain the property in a good condition, fit and habitable. If you're a landlord, you don't want to get a bad reputation of being a slumlord. So what does that mean? Safe and sanitary and accessible as determined by the housing codes. Repairs completed in a reasonable time. You know, if your toilet breaks, you need to report that to your landlord right away. And the landlord needs to get there probably within 24 hours to fix something like that. Not required to pay for or repair damage caused by the tenant. If you have a fight in the unit and something gets broken, you can't expect the landlord to go running over there to fix it because it's something that you caused or that you did. What would be an example of that? Your children are throwing a football and it busts the window. They're throwing it inside the house and it breaks the window. The landlord's probably going to send somebody over there to get that fixed right away because they want to make sure that your unit is safe, but they're going to put it on your bill and tack it to your rent. A multi-unit building. Landlord is responsible for maintaining the common areas. Also, to meet safety and cleanliness standards, a landlord must provide drinkable water in the kitchen and bathroom, functioning bathroom with a toilet, we talked about that, the shower and tub, safe and functioning electrical system, no broken locks or doors and windows, accessibility, and working fire escapes. That could be a building code violation. Hot water, heat during the cold months, are no cool air required unless written in the lease. I think that what they're referring to is air conditioning.
Right.
working sewage system, working smoke alarms, and no leaking roof or broken windows. All reasonable requests. A landlord must inform a tenant of lead-based paint pipes in the property before a tenant signs a lease. Landlord can be sued for triple the amount of damages. I've never had a situation like that in my 28 years on the bench, but I am familiar with it. If the tenant pays the utilities separately from the rent, the landlord must install separate meters. That can be an issue. If you have an old building and you have 1 meter and you converted it into 2 units, but it's on 1 meter and you expect the tenants to split the utilities, you can't do that. Because what if the tenant downstairs is home all day and the tenant upstairs isn't? How are they going to split the utility bills? If they cannot be metered separately, the landlord must pay the utility bill and add it to the rent. If a tenant tells the landlord that the smoke alarm is broken, the landlord has 72 hours to replace it.
Next slide.
A landlord cannot do the following to a tenant: take or sell a tenant's property if they do not pay the rent, shut off utilities, or lock a tenant out of the property if they do not pay the rent. I had a situation where a landlord took the door off the unit because the tenant was behind in the rent. Harass a tenant. What's harassment? It's what a reasonable person believes. Enter the property or allow others to enter the property without giving notice except in an emergency. What's an example of that? The landlords, you've been in the unit for 6 months, they want to do a safety inspection or something like that. They give you 48 hours notice and let you know when they're coming in. And when they do enter, you have a right to be there. I would advise you to be there if that happens. If you are not there, they should leave a note saying when they entered and when they left, unless there is an emergency situation. For instance, they're driving down the street and they can see their property and water's running out the front door. They need to run up in there and shut the water off. Require a deposit for an assistance animal, medical prescription. Cancel an existing lease of the tenant if the building is sold to a new landlord. They can't do that. That has happened many, many times.
Yeah, and you know, sometimes what happens, unfortunately, is that people sell buildings and don't really tell the truth about whether there's a rental unit in the building. So you may be caught off guard by a new landlord, or the new landlord may be caught off guard by the new tenant. So again, you know, communications is important to inform and make sure you stay alert. I wanted to say one thing about entering the property. I mean, if you are working during the day and you can't, you know, be there, right, you're not expected to take off while the landlord enters the property. But if you have a friend or, you know, know another tenant in the building who could sit in the apartment, I mean, I would ask. This way, at some point, maybe you can reciprocate the favor to them.
Good suggestion. All right, lease agreement. It's the most important document in the landlord and tenant relationship. How do I know if whether or not the landlord has a contract with the tenant? There is a lease. Sometimes the leases are 27 pages long. And I'm going to tell you, many people are not going to read 27 pages. They're going to sign, they're going to give them the first month's rent and security, and that's going to be it. Sometimes they end up coming to court and don't even realize that they agreed to something because it's in the lease because they didn't read it. But the lease is going to spell out some very important things. First of all, it's going to tell me how long the tenancy is going to be. If it's a 1-year lease, let's suppose it starts on January the 1st and it ends on December the 31st. It's also going to establish what the monthly rent is and what date the rent is due. It's also going to tell if whether or not there is a late fee and what day the late fee will be applied. In addition, some leases even have waivers of notice, and we'll talk about that a little later. So what is a lease? A lease is an agreement between a landlord and a tenant that a tenant can occupy and use a property for a certain amount of time in exchange for rent. It's a contract. Be sure to fully understand and agree with its terms before signing. Now, we talked about making sure that you get a copy. So often, the tenant never has a copy of the lease. Once they sign it, the landlord doesn't even give them a copy, or something happens and they don't even have a copy of the lease. Leases can be oral or written. An oral agreement is technically month to month. If agreement is for more than 4 years, it must be in writing. Oral agreements are legal. However, if you end up coming to court and there is no contract, how am I going to make a determination as to if whether or not what you all agreed to, particularly in situations where you may have to pay light and gas, but you didn't know you had to pay water. And the landlord says, no, I said all utilities. Well, it's not in writing. Who am I going to believe? The lease must be written in plain language, no fine print. Meaning, sometimes landlords pull leases off of the internet. Well, sometimes the internet may use a lot of legal terms or run-on sentences, or they may have language in the lease that may be ambiguous. In a situation like that, if I don't understand it, I'm gonna err on the side of the tenant, because that's on the landlord to have a language that everybody can understand. Once signed, the terms cannot be changed unless both parties agree.
I'm going to follow up on you. Sometimes landlords just pull a lease off the internet and it's not even applicable in Pennsylvania, right? So it's really important that, the lease contains language and law, complies with Pennsylvania laws. And I always say, when we discuss some of the issues between a landlord and tenant, take pictures. We all have cell phones now. You can, you can take a picture of 20 pages if you have to, but that lease is really important. Documentation is really important. Next slide, Leah.
Okay, what can a lease contain? The lease term, what date is the tenant allowed to live there? When is move in, move out? Let's suppose we have a lease that doesn't start until the 1st of the month, but the tenant was allowed to move in, say 10 days before the lease started. They may be student or something like that. They may have to get in there. So, but the actual dates of the lease are not until the 1st of the month. Repairs, who makes repairs? More than likely, it's going to be the landlord that has to make repairs unless they're caused by the tenant. Smoke alarms, who's responsible to check the smoke alarms? If I was a tenant, I would check my own smoke alarm. However, the landlord should have a regular time schedule as to when they come and check the smoke alarms. Visitors, can others stay for an extended amount of time? That's an important issue as well. The right to peaceful and quiet enjoyment. Does that mean that your boyfriend can come over and stay with you for a whole month, but that person is not on the lease because he or she has their own place? Okay, so those are some of the issues that I get when making a determination as to who has the right to be there. And then how can you establish how long a person can stay in someone's unit? Limited locations on property. Entering, must the landlord provide the tenant notice before entering, and when, how, and why? I would say yes. If I was a landlord, there's no way I would enter a tenant's property without providing notice unless it was an emergency situation. That protects the landlord, that protects the tenant, because that could put the landlord in a very tough situation. Particularly, let's suppose someone is enjoying their property and they may be indisposed and the landlord comes walking in or something like that. Who pays for which utilities? Some landlords will pay the electric, gas, and water, and some and the light. And some landlords will pay only 3 of them, and you have to pay the water. Are there any late charges? That's a whole other issue I have to look at. I've seen late charges as little as $15. I've seen them as much as $175. When they get up in that $175 range, it's usually a unit where the rents are probably in excess of $1,500 or $2,000. Who's responsible for snow, for leaves, for trash? Very important stuff. Let's suppose the tenant is responsible for the snow, but they don't do it, and the landlord has to do it. Let's suppose that the tenant is responsible for the leaves and for the trash, and the landlord has to do it. So if I was a landlord, I would be responsible for my own snow. I wouldn't take the chance of having someone fall on the property because the tenant didn't shovel the snow. For the leaves and for the trash, those things can be spelled out in the lease. Renewal or termination. Can a lease be renewed or does it terminate? If month to month, will automatically renew unless the tenant or landlord gives at least 15 days notice before the current term ends.
So as you can see, there is a lot of information that you need to have a conversation with if you're a tenant with the landlord, if you're a landlord with the tenant. There is a lot to talk about.
Okay. Beware of the fine print, security deposit. I think I mentioned that. During the first year of the lease, cannot exceed 2 months rent. So in other words, if your rent's $500 a month, your security deposit can be another $500 or an additional $500, meaning $1,000, but it can't be more than that. During a 2-year lease, cannot exceed 1 month's rent. In a 3-year lease, the security deposit over $100 must be put in an interest-bearing account. So if you've lived with your landlord for 20 years and you paid a security deposit, and let's suppose the security deposit was $500, the interest amount could be pretty significant after 20 years, or 15, or 10, or maybe even 5. When moving out, tenant must provide landlord a forwarding address. Some tenants don't do that because they don't want the landlord to know where they are. But if you want your security deposit back, you must give them the forwarding address immediately and return the unit to the condition in which it was found in order to get your security deposit returned. A landlord has 30 days to return your security deposit. And if any money is deducted, the landlord must provide a written list of deductions for actual damages. For instance, you paid $1,000 security deposit, but let's suppose that they had to replace a carpet because you spilled paint on it, or replace a window or something like that because your kids broke the window. They have to provide you a bill for that. They have to deduct that from the $1,000, and whatever is left, you are entitled to that money. If you left the unit in the same condition as when you first moved in, you should be getting your whole security deposit back. Now, if any money is deducted, the landlord must provide a written list of deductions for actual damages. If itemized lists and monies are not returned to the tenant within 30 days, the tenant can sue for twice the amount, provided you provided your address to the landlord. Okay, waiver of the notice to quit. What gives a judge like myself jurisdiction is the notice requirement. So some leases have a waiver of the notice to quit. So if you got one of those 25-page leases and you never looked at that and saw that, you may not know that you were giving up your right to have notice. What is notice? That's the notice that the landlord puts on your door. It's either 10-day, 15-day, or 30-day notice. 10 days for non-payment of rent, 15 days for a breach of a lease condition, and 30 days if you're not renewing the lease, depending on what kind of lease that you have. So if you sign a lease that has this clause that you are waiving your right to notice, the landlord does not have to give you notice of eviction. Instead, the landlord can take direct legal action without telling the tenant that they're going to court. Now, let's suppose that you have signed a waiver of the notice, but the landlord provides you written notice anyway. It can be said that the landlord has waived their own notice in the lease requirement because they provided you in the lease because they provided you written notice and handed it to you.
We did that, Leah. Go ahead. Don't worry. Go to the next one. I'm looking at time. So, all right. We end up in court because of disagreements between a landlord and tenant. So first, I always say, if you can avoid court, you should. Sorry, Your Honor. I don't mean to insult you, but if people can resolve it amongst themselves or with the assistance of somebody else, a mediator, a neutral third party, maybe another tenant in the building, I would strongly recommend that you do that. Again, this is when you get to court, it's one person's word against another person's word. So if there are, repairs that need to be made, if there are conditions that are uninhabitable, take pictures. Make sure they're on your phone. Make sure you send pictures. Make sure that every either an email or text, and save those emails, save those texts. I hesitate or hate to say this, but phone calls aren't recorded, so it's hard to prove. And in Pennsylvania, you actually can't record phone conversations unless you notify the other party and have their permission that you're recording. So you're better off taking pictures and writing everything down. The judge discussed about repair and deduct. Sometimes tenants say, okay, I'm just going to repair this on my own and deduct the costs from my rent. That's not always proper. If maybe it's been a while that the tenant has notified the landlord hasn't come out, and this is a serious matter, yes, the tenant can go and hire somebody to make the repairs, save the receipts. Don't hire a friend and fake a receipt, but make sure that the tenant has informed the landlord that they're going to go hire somebody else, and that the landlord will be responsible. Your Honor, anything to add?
Well, Deb Gross is right. I've often said that coming to court is next to death.
I didn't say that.
That should be your last resort. And oftentimes I will look at litigants and I will look at the issue and I will say, did you all ever have a conversation? No, I just wanted to come straight to court. So you want me to work this out. This is something that you all should have been able to discuss between yourselves. You come here when that discussion didn't work. So if you can resolve an issue, and it's probably going to be through communication with your landlord to prevent either one of you from coming to court, that's the best situation. However, if it can't get resolved that way, then court's going to be your only remedy. All right. So, can a neutral third party assist you in a resolution? Yes.
And in Pittsburgh, there is this organization called Just Mediation, which will provide a mediation service at no cost. It is free. They are terrific. Sometimes they're much busier than others, so it's not something that you can call them right then and there and expect it to be resolved. But I urge you to reach out to them.
Now, my court is one of the courts that has folks in the waiting room providing assistance to tenants and landlords before they even come into the courtroom. People were having trouble paying their rent, neighborhood legal services. I even met with Just Mediation prior to them coming to my courtroom to talk to litigants and to see if whether or not that I'd be willing to refer any of my cases to them, or before it actually got to court. And I said, absolutely. So if you can get an outside resource that is used to handling conflicts amongst parties, then I would certainly support reaching out to those groups.
Sometimes even the bar associations have a service, that'll assist with some kind of mediation or reconciliation. For some reason, this slide is out of order, so everybody knows, but it just deals with early termination. And again, as a tenant, there's no right to terminate the lease early, right? There's an agreement. It has a start date. It has an end date. If for some reason the tenant has to move, and the tenant has to end the lease, it's understandable, but the tenant's still required to pay, unless for some reason maybe the tenant can locate a new tenant, and it's permitted by the landlord. So it can't just let somebody move in without informing the landlord, but you have to have a conversation and get the landlord's permission. So the tenant cannot just end the lease.
I just had a case recently involving some young college students, and they didn't get along with their landlord, and they brought the other tenants in the building as support who wanted to testify about some of the issues they were having with the landlord. Well, her lease didn't end until July. She left in April. So the landlord was suing her for June and July's rent. Well, one of her own witnesses testified that she had the same issues, but she at least paid June and July. She knew that she was obligated by the lease. So that truly didn't help the litigant's case, because her own witness says, well, I had the same problems too, but I just went ahead and paid June and July. So they have all since moved out, but the landlord ended up prevailing in that situation.
Okay, so now we will talk about what happens, right? When I'll say communications break down.
All right, what's an eviction? A landlord can decide to evict a tenant for the following reasons. The term of the lease has ended. The tenant has violated conditions in the lease. The tenant has failed to pay rent, or illegal activity by the tenant. And all of this stuff, has to be shown that this is a lease violation. The landlord just can't come without evidence.
Excellent.
Notice must be provided before any eviction process can begin. It's called a notice to quit. Sometimes a landlord may leave a letter and said, and when I asked them, did you provide a notice to quit, they'll present the court with this letter. And it's very confusing as to whether or not that is a notice to quit. I just tell them, put notice to quit at the top of the letter and put the date there, or notice to vacate. Then it's clear that it's a notice to quit. The notice must include the following information: name and address of the tenant's rental unit, the date the notice was served, the reason for the notice, the total amount due, including any late fees, where the payment should be made, and to whom the rent should be paid. If reason is failure to pay rent, tenant has 10 days to pay or leave voluntarily. If reason is any other breach of the lease, the tenant has 15 days to leave voluntarily. An ultimatum to the landlord may bring forth an eviction lawsuit. But the landlord cannot come and just lock your door. All right, let's talk about going to court. Let's suppose it gets to that point where the landlord goes ahead and files a lawsuit. If the landlord wants to evict the tenant, the landlord must sue the tenant, take the tenant to court, and get a court entry of judgment and order possession, allowing a tenant to be evicted. So remember when we talked about years ago when they used to just come and lock your door and put you out on the street? Well, under the 14th Amendment to the Pennsylvania and the U.S. Constitution, it requires due process of law. Due process is two things. Number one, notice, and number two, a hearing. Now, but it should involve something which is what is called a fundamental right. What's a fundamental right? Right to free speech. You may have heard about that. The right to be able to move about freely. That's why when someone gets arrested on a criminal case, they have an arraignment, a preliminary hearing, and then it ends up going through the whole court process before they may either be convicted or found not guilty. But what's being taken, what fundamental right is being taken from that person who gets arrested on a criminal case? It's their freedom. So you just can't lock people up. You have to give them two things: notice and a hearing. Now, is having a roof over your head a fundamental right? It depends on the legal argument. But I know in Pennsylvania and in all states across this country that you cannot just lock a tenant's door. You have to give them due process of law, which is notice and a hearing. So if the landlord wants to evict, the landlord must take the tenant to court. So how does the civil suit work? Okay, and well, landlord and tenant cases do fall under the civil suits. My jurisdictional limit, and it may come up again later, is $12,000. So the suit involves two litigants, the plaintiff and the defendant, and it determines whether the defendant is liable for injury or harm done to the plaintiff. Plaintiff must have a preponderance of the evidence and no rights to an attorney. And let's talk about that no right to an attorney real quick. In a criminal case, you have a right to an attorney.
Right.
Okay. Very famous case many years ago back in the law school days. What is it? Gideon versus Wainwright.
Gideon versus Wainwright. Yep.
Was that it? Okay.
Yep,
all right.
you got
I think it happened in Cleveland, Ohio. Okay. Well, that case was what started public defender's office providing free services to those folks who are indigent and cannot afford a lawyer. It used to be that the people who had the money to afford a lawyer were the ones that were able to defend themselves. Well, now in a criminal matter, everybody is entitled to an attorney. Not in a civil case. You have to, if you want a lawyer, which you can do, you have to hire that. But the government is not going to provide, or the state is not going to provide an attorney for you. So who is involved in this landlord and
So
tenant?
I'm going to just say one thing so everybody knows this, and you can get involved if you want in advocating. But landlord tenant matters, they do not provide a lawyer. But in Philadelphia, for example, city council and the mayor have signed a bill that provides for funding for a lawyer for a day program. So there is a lawyer, in court for that day that can help in landlord tenant matters. So it's only Philadelphia. We've been trying to work with other organizations to get it across the state, but it's not there yet, just so everybody knows.
And let me just say something. That is huge. Now, in the situations where not the public defenders, but neighborhood legal services is in my waiting room, and they get a chance to talk to the landlords, and sometimes I'll talk to the landlord as well. And I can tell you a situation where a landlord was wanted this person out right now. And I said, we have these resources that are available. If you can just wait, there may be a good chance that we can get this back rent paid and you don't even have to come back to court. And that's exactly what happened. But I'm gonna tell you this, when there is a neighborhood legal services lawyer in this courtroom, it makes my life a whole lot easier. And the tenant doesn't have to worry about all the legal issues. Your lawyer will handle that for you. So where is the lawsuit filed? The landlord may sue the tenant either in the local magisterial district court where the rental unit is located, in the court of common pleas of the county, where the rental unit is located, if the matter involves more than $12,000. First step is the complaint. The landlord and or the tenant files a complaint with the magisterial district court where the property is located. There are fees involved with filing a case. And nowadays, everything is online. Forms are available at the district court or online, and the address is there. The court may have advocates, interviewers to assist in completing the necessary forms, but this is not legal advice. My staff knows not to give legal advice, but they can instruct a person filling out a complaint generally, okay? Every complaint must include your name and address, amount for which you are suing, and a short statement explaining why you are suing. And I'm gonna tell you what, that little box that they give you to write that short statement in, it's not very much. A defendant can file a counterclaim up to 5 days before the hearing. Okay, let me see. Oh, I missed something. The complaint may be served by a court officer and or registered mail and or posted on the rental unit. The complaint explains that the defendant should respond to it. The court provides a date for a hearing, generally within 7 to 10 days after service. So why is that? Because landlord-tenant issues are something that you want brought before the court in a timely manner. It used to be that they didn't come to court within 7 to 10 days, but we know when we get that filing, we have to work that case in within 7 to 10 days after it's been served. A defendant can file a counterclaim up to 5 days before the hearing. This could be because the tenant wants to sue the landlord at the same hearing for any expenses such as back rent or repairs.
Next.
So what happens next after the complaint is filed? The plaintiff must then serve the complaint on the defendant. If the plaintiff does not serve the defendant or service is defective, then the case will be dismissed. Usually what happens in our office is it goes out by certified and regular mail. The constable will actually post the door of the unit. So usually we don't have a problem with service. The court will set a hearing date. If the defendant does not show up, the court may enter judgment against the absent party. If the plaintiff does not show up, the court may dismiss the case. The defendant can request a continuance to move the trial back, and the court may grant such continuances if justice so requires. Let's suppose you're getting surgery on the day of the hearing. Well, then that would be a good reason to ask for a postponement, but you want to do that in a timely fashion as well, particularly if you know you're having surgery and it's right around the time that you're scheduled to come to court. What we don't want to do is give someone 1 day's notice, although we've done that before. What happens next after the complaint is filed? And what a landlord should bring to support a case? The written lease. Yesterday, 3 landlords didn't bring a lease. When I'm sitting on the bench, I can look over to my left and look and see what's in their hand to see if whether or not they're going to be able to make their case today. housing inspection license if operating a multi-unit building, a copy of the notice to quit unless the lease waives the notice, unpaid utility bills if the lease requires the tenant to pay them, photographs of damages, proof of payment, invoices and estimates, communications between parties about any damages. When in doubt, bring everything with you.
So I am worried it's 7 o'clock and I honestly don't know how long the library stays open. So Sarah, how are you doing there? We probably have another 5 minutes before Q&A, or should we stop and do Q&A and we can circulate the PowerPoint?
So we are technically closed, but I'm the manager, so I'm happy to remain open and let us get through as much of the presentation as we can, and then we'll let our folks ask some questions. So
okay, fine. I just
like
want to make
10
sure.
minutes, we're totally fine.
Okay, great. Thank you very much.
Thank you.
Thanks, Sarah. I appreciate
What
it.
a tenant should bring to court: to sue for repairs, habitability, running water, the written lease, pictures of the conditions, notices to the landlord of the conditions. To sue for a security deposit, should have a copy of the written lease, documentation that the key was returned and a forwarding address was provided, documents from the tenant to the landlord demanding the return of the security deposit. When in doubt, again, bring everything with you. What happens at a trial? Make sure you bring all your documents and have witnesses ready. The judge will explain the procedures. The party filing the complaint is the plaintiff. They present their case first. Oftentimes, defendants just want to speak, and many times they are speaking out of turn. And I will tell them, you will get an opportunity to speak. The opposing party, who is the defendant and the judge, are permitted to ask questions. After all the facts are presented, a judge has asked all their questions. The judge may decide a matter at conclusion of the hearing, or hold the decision for up to 3 days after the hearing, or entry of the judgment. The order for possession. Let's suppose that the court rules in favor of the landlord. The landlord still cannot evict the tenant by themselves. So in other words, you lose in court, it's not over. They can't just go and lock your door. The landlord, the tenant has a right to appeal. If it's a possession and they want their unit back, the landlord must wait 10 days after entry of the judgment and then ask the court to issue an order for possession. The landlord has to physically come back into the courtroom after the appeal period is over, not into the courtroom, but through the window, and file what is called the order for possession. And then they still get another 11 days after that before the locks can be changed on the door. So anywhere in between that time, that's about 21 days after the court appearance, the tenant can still catch up on their rent, and the landlord has to take it unless the judge gave them possession of their unit. The court will serve the order for possession by mail at the last known address, and the sheriff will serve the tenant personally or by posting it conspicuously at the leased property. The last known address is going to be the address where you live. So in other words, if they filed a landlord tenant case on you before you left and then you moved, all the notices are going to go to your same address, the address that you moved from. So you should have an arrangement with the post office to have your mail forwarded so you don't miss these notices. The order of possession requires tenant to vacate within 10 days after the date of service. If the tenant remains in the unit on the 11th day, the tenant can be forcibly evicted. If the tenant is forcibly evicted and leaves possessions behind, the landlord must notify the tenant by first-class mail the right to retrieve that property. The tenant has 10 days from the date of notice to retrieve the property, or ask the landlord to store for up to 30 days. If the landlord stores the possessions, the tenant is responsible for the cost of storage. If the tenant doesn't retrieve the property, the landlord can dispose of it. Obtaining a stay of eviction. If a judge has entered a judgment against a tenant must file a notice of appeal within 10 days to pause an eviction. If the tenant files a notice of appeal, that stops the eviction process, and it is a de novo hearing in a higher court down at the Court of Common Pleas. De novo means this: it's a brand new case. So the judge is not going to know what happened at our courts, what happened in the previous court. It starts all over again. So let's suppose you weren't really prepared the first time. Now you know exactly what you need to bring, and on the appeal, you can bring it then. So if a tenant is a victim of domestic violence, the tenant has 30 days to appeal or file a domestic violence affidavit. If a tenant does this, the tenant must deposit with the court either 3 months rent or the judgment amount ordered for the tenant to pay, whichever is less. It means this. So if your rent's $500 a month, in order to appeal, you're going to have to post 3 months back rent or the judgment amount, whichever is less. 3 months back rent in that situation would be $1,500. But it wouldn't be $1,500 if your judgment's only $500. You would only have to pay that. Now, if a tenant is a low income tenant, the tenant may qualify for what is called an informa pauperis waiver. This waiver will allow the tenant to pay only 1/3 of the monthly rent into an escrow account. The other 2/3 will be made payable within 20 days. So on an appeal, they will put you on a payment plan if you cannot afford the 3 months back rent.
So what I also say for everybody is that sometimes it's not obvious where the informa pauperis like forms are. You need to ask the clerk about them because they are there. They aren't always, signed well, but it's something that is available. Filing of responses. There are informa pauperis forms to waive some of those filing fees.
And this is huge. I've been on the bench for over 27 years, and probably within the last 5 to 8 years that this ruling came down that if a person was indigent or could not afford to pay the 3 months back rent or the judgment amount, that they be allowed to fill out a form. The court would make the determination to see if they qualified for informa pauperis and then put them on a payment plan.
Right.
Now, appealing a decision, again, if a landlord or tenant wants to appeal a decision, they must first file a complaint with the Court of Common Pleas.
And so this just tells you there's a help desk in Allegheny County, and that will help you with filing an appeal and the forms that you need. Next slide. And this is just a bunch of resources that we've provided. We will, as long as we have your email addresses, we will send you a PowerPoint of these slides so that you can have the resources available to you. And I think we're out of slides. So we are here to answer any questions anybody has. Feel free to ask them. Again, we can't give legal advice, but we can provide information.